Hi friends, this is about the opposition proceedings. Now you have convinced the examiner of your good arguments beside having received an objection letter, and the examiner is convinced that you are right, or the examiner didn't find anything on the absolute grounds and everything proceed to publication. Now, in some jurisdiction we have registration and then opposition afterwards. In Europe it's the other way around. We have only a publication, then the opposition, and only after opposition we have the registration. Now, the opposition proceedings that go both ways, right? Either you are on the opponent side or you are on the defendant side. One time you are on one side, one time you're on the other side, meaning that the explanation I will give you are for both ways. So if you are on the defendant side, you take care of that part. Of your opponent side, then you take care of that part. Now, that is the opposition. Opposition deadline is 3 months from the publication onwards. How do you spot an opposition? So for the opponent, how do you spot this, that there is something published which you want to object to? Well, thank you for the good question. That is not easy for you as a trademark holder. So either you have an agreement with your client that you supervise regularly the publication of EU IPO and spot similar marks to make a feedback with the client. Well, this is a similar mark. Do you want not to oppose against that? Or you have already in contact with a European lawyer and he does this supervisory work, or there are special services also in Europe who do just that. Or you might get just a letter from a trademark lawyer which you never have heard of, who tells you that here is a trademark which is confusingly similar, and if you as a client, you as a lawyer, or your client on his behalf, so if there is something to be done, so the lawyer naturally is acting in its self-interest, right? So this is the situation with regard to the opponent. So you have to be careful if you want on the behalf of your client. Look at these new trademarks which are about to be registered, which are published for registration afterwards. Then you have to do this kind of supervisory work. Now, what are the grounds of opposition? So very easy. We have the Article 8.2 of trademark regulation, here it is, which puts out the different grounds of the opposition. So there are different ones, and I will not go into everyone's. That is not necessary. What would be a deeper course for European trademarks, which European trademark lawyers, where I would line this out, but you should not go into too much detail. You should know, though, that we have in Europe the two-layer system. Well, you know it already because I mentioned it already. A two-layer system with the national trademarks and the EU trademarks. And the national trademarks, they can also base as a ground of opposition, which is normal, because if that trademark is in, for example, in Germany, in German trademark office, that is part of the European Union, and it cannot be protected in Germany because it is confusingly similar, then it cannot be protected in the EU because it's a unitary title, right? So national trademarks can be part also of the earlier trademarks on which opposition can be grounded. Now, that expands a bit what is the groundwork, right? We talked about earlier trademarks. Now we have to the earlier national trademarks as well. which we have to put into the equation. Well, it is not only the trademark, the registered trademark, it is also those which have an earlier filing date. So we talked about the filing date before. The filing date is the one when you can act upon. So you get a certain value already from the filing date onwards. Now, the filing date is one thing, but an opposition can be ruled in your favor only if it proceeds afterwards to registration. So if it is a filing, you got a filing date, but you got an opposition yourself, and the opposition is admitted and your trademark is rejected, then you cannot base, or you cannot be awarded with a positive opposition decision in your favor on the basis of a mark which do not exist anymore. Correct? Okay. So this is about the grounds of opposition. Now let us talk about the timeline. The opposition has 3 months in order to put an opposition in. So 3 months from the publication. It has to be done within that 3 months. So within that 3 months, it has to arrive at the EU IPO in order to be in time. And this is an absolute deadline, so it cannot be extended. There are relative deadlines, which I come later to, but this is an absolute, so no extension possible. Then, after, so to say, the payment, you have to pay 350 euros in order to put this forward, to be admitted, to get to the admissal stage, formality required admissal stage. The opposition is being admitted. Now there's one speciality here. This has to do with conciliatory agreement. So in oppositions, although your groundwork is very sound, and I don't doubt that you do it now from now onwards, but there can be always some oppositions which you could not be foreseen. You could not, well, there are earlier rights which you may not know in the registration, or you may have overlooked, and then it comes up. Now, in the past, what we had before the reform, what we had is a cooling off period. So there was an opposition inside, so presented, and then the further proceedings were suspended, so to say, for a year or 18 months in order to the lawyers, the different lawyers, talk to one to the other whether there is a settlement, amicable agreement possible. And amicable agreement could be any kind of agreement, in the sense that, well, you change a bit the trademark, or you suppress that part of the trademark as a figurative mark, and the figurative element is the one which is similar to the opponent's mark. Or if it is you asked for 10 classes of goods and services, and they say, well, the opponent says one class, I'm particularly interested that you do not file for it. And you say, well, I have 10 classes and this is not one of my core products, so I will drop this. And we come to an agreement. So the agreement can come from whatever interest the parties have. You never know what are the core interests of the parties. And there is a possibility to come to an agreement. And in fact, a lot of oppositions have been settled by amicable agreement. Now, if that is the case, amicable agreement, then you set up the agreement among yourselves, among the lawyers, and you talk also about the fees. The fees to be paid to the EU IPO, so the 350, I think it is, opposition fee, and about the honoraries, the fees of the lawyers. And this settlement is among you. You do not need to bring this to the attention to the EU IPO, just that you both put forward a submission to EU IPO that you have settled and that no decision is necessary. And then the EU IPO would take notice of that and close the proceedings in one or the other way. Or you just say that the opponent, you're the opponent, and the opponent withdraws the opposition. There's no justification needed, and that's it. And then you internally, you have decided on the ground how to make the financial agreements and what is the core settlement you have made with regard to the goods and services or the trademark, right? So this is a cooling off period, which is now not anymore mandatory, but you can opt in order to have this conversation with the other party in order to come to a settlement. Now, leaving apart the conciliatory part, so what happens now with the proceedings is that after the formality check, the payment, and the formalities agreement admissible, your opposition is admissible. And you get now a deadline of 2 months, but this is an extendable deadline in order to put forward the facts, the evidences and arguments with regard to the opposition and the other mark. So you can take one earlier trademark, 2, 10, 20, 500, whatever you have as earlier trademarks, and there are similar with regard to the goods and services, then you can put them forward. It will not cost you more. It is one fee as a lump sum for everything, right? Now, once you submit your brief, then the brief is sent to the defendant, and the defendant has been given another 2 months in order to submit its own arguments, facts, and evidences. And then there may be another round of the opponent and the defendant, the replique and the duplique, in order to fulfill the full round of submissions from the parties. Now, you want to, who decides on that? There are 3 examiners. It was from the absolute ground, there was only 1 examiner. Here in the opposition, normally it's 3 examiners. One of them is being appointed rapporteur, who is in charge in order to draft the decision, and the others 2 act as co-signers. Can you have a small talk with the rapporteur in order to see where he is going, what his intentions are? No, you cannot. Even if you know the rapporteur and you get hold of him on the phone, he will not tell you anything. That is, the proceedings is that everything should be known to everybody from the parties, so the 3 examiners and the opponent and the defendant, they must have the same knowledge about everything. So it cannot be that there are some side talks between one party and the examiner and the other doesn't know, etc. That cannot be done. So that brings us to the decision. The decision will be taken once the rounds of briefs have been terminated, and the opponent says, well, the opposition division says, well, this is now stopped and we will issue a decision. Then a decision is issued to both of the parties, right? Now, it can be rejected, it can be admitted to the opposition, or it can be half-half. So it can be partially rejected or partially admitted. In any case, those who are negatively affected, it can be both parties, right? If it is partial, then they can go to an appeal stage. So they would be possible, and this is indicated at the bottom of the page, as it was in the examination decision we talked about last time. So that is it, what I want to tell you about the opposition decision. Just one thing, there may be, and this is now from the strategic part from the examiner, which you should know. If there are, for example, 5 or 6 earlier marks which are indicated by the opponent, then the examiner is saying, oh, I have to go through 6, 7 marks, now I have to for each mark, this class and that class and this class against that, and so goods and services and so on, that would give me 50 pages. I will not do that. How can I do it more better? Or can I do it better? And then what they would do normally, they take the strongest earlier mark, so with regard to the trademark and the goods and services and the similarity of the trademark opposed, and they would come to, well, admittingly, they would come to the decision that the opposition is well-founded, then they would not need to go into all the other. Or the other way around, if they would feel, would come to the conclusion that the opposition has to be rejected, it has to be rejected even a fortiori with stronger reasons for all the weaker marks. So again, they would not need to go into the different weaker trademarks, earlier trademarks. So from your point of view as a lawyer, you would say, well, the strongest mark, I will most put my effort into justifying that this is the strongest case, and I would put all my arguments into that. That's what you should do. Thank you for tuning in for this time.